What does the Najib case teach directors of companies? Why is this case important? Two classes of people are directly affected by this decision. The first are controlling shareholders of a public listed company. The second refers to a director of the board of a public listed company or any company. Now let's deal with the Najib case, or what is known as the SRC case. Najib was recently charged under 3 different criminal laws. First, for using his office or position as Prime Minister for gratification either for himself or for an associate. Second, he had breached the trust placed in him as a public servant or agent. The third charge was one under Section 4 of the Anti-Money Laundering, Anti-Terrorism, Financing and Proceeds of Unlawful Activities Act 2001, or what is known as the AMLA Act. Some history. For many decades now, a controlling shareholder of a company, whether public or private, as well as a director of any board of directors, have always had a duty. This was known as fiduciary duties. What does fiduciary mean? It means a trustee. What should a trustee do? A trustee must always act in the best interest of his beneficiary, and therefore directors are trustees to both the company and its shareholders. If a fiduciary broke his duty of trusteeship, he could be sued in 2 different ways. The first was a civil suit, either under the common law or under various statutes. There, the beneficiary, in this case the company, would usually seek monetary damages as well as an order to remove the director and to ask him for compensation and trace into his assets. The Najib case does not add any new extra dimension to the old law. The law in this area was established over 120 years ago. It all started with the 1902 case of Percival versus Wright. Now that case concerned a company called Nixon's Navigation Company. Its shareholders wished to sell their shares. They asked the company secretary to find them buyers. Now, some directors of the company purchased the shares at £12 and £10 respectively. Now that price had been based on independent valuation. After the sale of the shares, some shareholders discovered that during negotiations for the sale of those shares, members of the board of directors had been involved in negotiations to sell the entire company's shares. Had the directors been successful, the value of the shares would have gone up, but the directors had not succeeded. The question was, did the director have any duty to the other shareholders? The other shareholders sued the directors. They alleged that few members of the board had breached their fiduciary duties, and they argued that the shareholders should have been told about all these negotiations. Now, in 1902, the court disagreed, ruling that there was no question on unfair dealing in this case. It was a question of fact. The facts didn't help the shareholders. Now, almost 100 years later, in 2001, the case of Paskin and Anderson described the ruling in Percival and Wright merely as a general rule. In Paskin, the court decided that in some cases, a director may have a greater duty to an individual shareholder, especially if such a shareholder was a vulnerable shareholder. He was in a weak position. What happened in that case? Now, some directors tried to buy a cinema theater, and that's a story. The leading case happened in 1942. It's called Regal Hastings Limited versus Gulliver. The story around Regal Hastings Limited is interesting. The company owned a cinema. To expand its business, Regal negotiated for the purchase of 2 more cinemas in a place called Hastings. Regal had 5 directors on the board, including Mr. Gulliver, its chairman. Regal incorporated a subsidiary company called Hastings Amalgamated Cinemas, and we shall call that subsidiary company as Amalgamated. Now, Amalgamated had a share capital of 5,000. There were 6 directors on Amalgamated's board. 5 were directors of Regal. Regal was only prepared to subscribe shares to the value of £2,000. The directors of Amalgamated only agreed to subscribe for 500 shares each, but Gulliver agreed to find investors, and he did so. Now, as a result, 200 amalgamated shares were allotted to a Swiss company. It was called Gulliver. 200 shares were allotted to another company called South Downs Land Company Limited, and 100 shares to one Miss Gehring. Guess who she was? She was Gulliver's friend. Now, Gulliver had his hands everywhere. Gulliver was Regal's chairman. Gulliver held minority shares in Gulliver, also in South Downs. Gulliver was also a director of Gulliver and the managing director of, you guessed it, South Downs. He signed Amalgamated share subscription checks on their behalf. The shares in Amalgamated were subsequently sold and at a profit. The question that the court was asked was whether the directors of Amalgamated had to pay their profit to the company. The House of Lords ruled that the directors had to account for profits to the company. The House of Lords ruled the directors and officers of the company could not take any personal advantage of the information within the company or violate their duty of loyalty to the company. Just because his conduct is not fraudulent or is not dishonest, it does not mean that the director is innocent. He still breaches his fiduciary duty if he has not acted in the best interest of his company. That is how high the duty of loyalty to the company is. So Regal Hastings versus Gulliver draws a clear separating line between the main shareholder-director and the company which he owns and his loyalty to the company. Can a director escape these strict rules? Sometimes he can. Breaches like these can sometimes be sidestepped if the shareholders later approve such conduct. It's called shareholder ratification. In Regal Hastings, for example, it was ruled that the breach of the directors could have been resolved if the shareholders had ratified the decision much later. But in their hurry, these directors from Regal Hastings hadn't done so. There is now a criminal sanction about which we need to speak. Now, a director could be prosecuted for breaching his trust duties with a crime. The sentences include imprisonment and very high fines. The Najib case demonstrates the criminal consequences of a trustee breaching his duties. What is the takeaway from this case? The first is that if Company A controls Company B and spends Company B's money, and if the decision makers are in conflict of interest, then the decision makers become liable, both in civil and criminal law. Second, the decision makers need not have personally benefited from their actions or decisions. It is enough if someone who is connected to the decision maker benefits, and that would be good enough to make the decision maker liable. So there you have it. If you're a director, you want to watch your step. Let's deal with this Najib case and how it affects civil cases. The criminal case in Najib concerns some discussion about what a shadow director is. You needn't know very much. The duties of a director are no different from a shadow director. The reason they are called shadow directors is because they are lurking in the shadows, and with unseen hands, they control what the board does and they determine what the board does. So if a person who's outside the board controls the company through the board or through other means, then the shadow director is as much liable as any other director who's formally on the records. That is what the Najib case teaches us. And there I leave you, and I'll meet you again. Goodbye.